All right, when I say your name, please say yes. All right, when I call your name, please say present or here, raise your hand, and then this being evidentiary day, I just want to get an announcement of what we expect to happen if we're having contested hearings, so I can schedule these accordingly. Is it Jacques Recall? Jacques Recall or Rachal? Michael Watkins? Chandler Chafee? Mr. Pogue, I see you. Brock Coleman? What are we doing on Mr. Coleman?
Judge, we need to confer with the state for a minute, please.
Michelle Stokes? Mrs. Stokes at plea today, Mr. Ashmore?
Yes, Your Honor.
Plea.
Yes, Judge, sorry.
Kendall Miller? Mr. Caceres here?
Good morning.
Oh, good morning.
I'd like to present this case for
I'll recall that in just a second. That's right. James Johnson.
Judge, he's here.
Thank you, sir. Michael Reisner. Mr. Reisner.
Even, Your Honor, I was told to expect him. I have a signed waiver of jury trial.
Josue Rodriguez. Mr. Rodriguez.
Mr. Versace is going on the paperwork.
They're in the hallway.
Okay, thank you. So that'll be Juvie Landaverde. Water.
Let's add that extra word on the end there.
I'm gonna write that one down as a good one, Carl. Carl's trying to steal all my content.
Trying to steal your followers, Judge.
Mr. White, are we anticipating a contested hearing today, or are we just waiting the results for UA to?
I think the waiting results of UA and goes.
We'll have a withdraw. If he's clean, it's a withdraw and continue because he's got like 2 months left. If he's dirty, then he's probably going with you, and Mr. White and I will figure something else out.
Okay. All right, and then Mr. Manis is in jail and Mr. Hortner in jail. Those were both set on hearings to administer the psychoactive medication. I'm going to reset those. I'm going to reset those at the court's motion so that I can discuss some issues with defense counsel, and also I'm going to have some discussions with Terrell State Hospital regarding this program that we're starting here to try to help have some kind of mental health intervention for inmates. So I'm not going to bring them up today, either this morning or this afternoon. I'm going to reset those, and once I get to a point where I'm ready, then I'll set it again and send a notice. All right, CR 15393, State versus Kendall Mark Miller.
Can we approach him?
You may.
We reached an agreement.
have anyone that's ready? You. Sir.
What was that you said to?
James Paul Johnson II. Mr. Johnson, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Your name is James Paul Johnson II, is that right?
Yes, sir.
Mr. Johnson, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes, sir.
Like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, sir.
Anything about the paperwork that you've read and signed today that you would tell me at this time you do not understand?
No, sir.
Mr. Manning, do you believe your client to be competent today?
Yes, Judge.
And you've gone over the paperwork with him and explained all of his legal rights to him?
I have, Judge.
I believe he understands all the paperwork and his rights.
He does.
All right, Mr. Johnson, I see here that you have been charged by indictment with a third-degree felony offense of tampering or fabricating with physical evidence. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 10 years and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
I see your plea agreement here that you want to enter into with the state is that you would plead guilty to that charge. The state would be recommending that you be convicted of that you be, your punishment be assessed at 4 years confinement in the Texas Department of Criminal Justice, a $1,000 fine, plus court costs, reimbursement fees. The DA's office would be asking the court to dismiss a resisting arrest, search, and transport, and you would receive 3 days credit towards that sentence for the time that you spent in jail. Is that your understanding of the plea agreement?
Yes, sir.
Understanding the range of punishment, understanding the plea agreement, you still want to go forward with the plea?
Yes, sir.
All right. Mr. Johnson, then how do you plead to tampering or fabricating physical evidence?
Guilty.
Mr. Johnson, are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
My court accepts the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection to state's one.
State's evidence is admitted and the court takes judicial notice of Mr. Johnson's judicial confession. Anything further from the state?
Yes, Your Honor. In the indictment, there is an enhancement paragraph. The state is abandoning that. If you'd like to notate that in the stipulation, that's fine. Beyond that, state has nothing further. We would rest and close at this time.
Defense rests on those.
I don't believe the enhancement is reflected in the judgment,
That's
but we're abandoning that. It would fit in either range, but for the paperwork's sake, we'll just abandon that.
Okay. And at your direction, I did. I just marked through it, but abandoned by state. All right, court's going to review the evidence. Was there a possession of controlled substance case associated with this?
No, Your Honor, because he ingested the narcotics. I would also note from the stipulation, Mr. Johnson does also have business in another county. We're getting out of the way for that. It's basically the thrust of this.
All right, Mr. Johnson, I've reviewed the evidence and I do find that there's enough evidence to convict you of this offense. The court will follow the plea agreement that you've reached with the state. The court hereby convicts you of tampering and fabricating with physical evidence with an intent to impair its availability. Court will assess your punishment at 4 years confinement in the Texas Department of Criminal Justice Institutional Division. Order you to pay a $1,000 fine, $290 court cost, $85 reimbursement fees. Court dismisses under section 1245 DA 2021-714 a resisting arrest, search, or transport. The court awards you 3 days credit towards your sentence for the time that you have spent in jail on this cause. Mr. Johnson, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted by Deputy McLeish, and then at that time she'll take you into custody. Okay, good luck to you, sir.
Judge, I believe that concludes my business. Maybe.
Mr. Wayne, can you approach? Well, Mr. Miller was clean, so we'll go ahead and call his case, and then I'll just reset to that. So you'll go ahead, he's not in here.
That's awesome.
Never happens.
That never happens.
I've got moments right. Just waiting. All right, this is cause number CR 12169, State of Texas versus Juvie Daniel Landaverdi. Mr. Landaverdi, if you'll step on up to the podium, please. All right, Mr. Landaverdi, the state has filed a motion to withdraw its motion to adjudicate, and they're also asking the court to terminate your community supervision. Court finds that you're now in compliance and that you tested negative on the drug test today, so the court is going to grant the state's motion to withdraw its motion to adjudicate. And today I'm going to terminate your community supervision. So you're free to go.
Thank you, sir.
All right. And so if you want a copy of this, then we'll file it. Perhaps Mr. White can assist you and get a copy. Okay?
Thank you so much.
You're welcome. Mr. Chafee, if you will, just to the best of your ability, raise your right hand. You can't go very high. There you go. That's good. Right there's good. Mr. Chafee, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got it.
Yes, sir.
All right, you may put your hand down. All right, your name is Chandler Dante Chafee, is that correct?
Yes.
Mr. Chafee, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes.
And have you ever been diagnosed with any type of mental health?
No, sir.
No?
Anxiety?
Anxiety? Okay. Are you currently on any type of medications for any mental health disorders or undergoing any kind of treatment?
Yes, sir. In Lynn Oaks, they said I had bipolar, but they told me that I take pink pill and I take Uspar and Seroquel for sleepiness.
Okay. And are you currently on those medications?
They didn't give them to me this morning, though.
Okay. Were you on them yesterday?
Yes, sir.
Okay. So, Mr. Chafee, do you feel like right now, knowing that you have these diagnoses and possibly these disorders, do you understand, like today, do you feel like you have rational understanding of what's going on? Your mind's working the way that you feel like it should be working so that you can understand what's going on here in court. You
Yes, sir.
understand what you signed.
Fully understand.
Okay, good, good. All right, and in this case, you are represented by your attorney, Mr. Mitch Adams. Are you pleased with Mr. Adams' representation of you being your attorney?
Yes, sir.
Okay, and do you feel like you've had enough time to talk to him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything, Mr. Chafee, about all of this paperwork, and I know there's a lot, is there anything that you do not understand about what you've read and signed in here?
No, sir.
You understand everything?
Yes.
Okay. And Mr. Adams, do you believe Mr. Chafee to be competent today? And if you want to touch upon any of his mental health issues?
Yes, Your Honor, in spite of his mental health history, which I'm aware of, in my conversations with Mr. Chafee about his case, about what he's charged with, the allegations, what my role in all of this is, what the court's role is, what the jury's role might be, what the prosecutor's role is, so on and so forth. He understands the proceedings against him, and it's my opinion from my interactions with Mr. Chafee that he is legally, mentally competent.
Thank you, Mr. Adams. And you've explained to him the paperwork, his legal rights, and have you also discussed with him the advantages and disadvantages of a deferred adjudication plea?
That's correct, Your Honor. We went over everything paragraph by paragraph.
All right, you believe he understands all of those things?
I believe he does.
All right, Mr. Chafee, I got to go over a few things with you. The first thing I want to discuss is the fact that the crime that you've been charged with is a second-degree felony offense of robbery. And a second-degree felony, if you were convicted and sentenced by either a court or a jury, the court or jury would be able to assess your punishment anywhere between the minimum of 2 years to the maximum of 20 years. It could also impose a fine of not more than $10,000. Do you understand that range of punishment?
Yes, sir.
Do you understand, Mr. Chafee, that if the court approves the plea agreement that you've reached with the state today, and that agreement is that you're going to plead guilty to robbery, the state's going to recommend to the court that the court review the evidence, not convict you today, but place you on community supervision for a period of 8 years, have you pay a $2,500 fine, court costs, restitution, and reimbursement fees. If the court goes along with that and places you on that, you understand that if you go on probation and you later violate one of these conditions that you've read and signed today, the state here could file a motion to bring you back before this court, and the court could hear the evidence of your violation, and then the court, if it determines that you violated, could revoke your community supervision. I could convict you of robbery, and I could assess your punishment all from the minimum of 2 all the way up to the maximum of 20.
Yes, sir.
You understand all those things?
Yes, sir. That I would be on probation as of today if I plead guilty.
Yes, you would be released. You'd go back to the jail. You would be processed out of the jail, and then you would be meeting with your probation officers and be placed on probation today.
Yes, sir.
Now, you're not saying that you're guilty of this just so that can happen. Is that right?
No, sir.
So in a moment, I'm gonna ask you if
have
you're,
fully-
if you're guilty of this. Okay, all right, so understanding all those things, I'm gonna ask you, Mr. Chafee, how do you plead to robbery? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty of committing robbery?
Yes.
Has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty today?
No, sir.
All right, court will accept Mr. Chafee's plea of guilt. Mr. Adams, any objection to state's evidence?
No objection is marked off.
State's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. The state is in compliance with victim notification and no response has been received.
Thank you, Ms. Heisel. All right, I'm gonna take just a few moments. I'm gonna look through the evidence, Mr. Chafee, okay? Size, can you approach Mr. Evans? All right, court has reviewed the evidence. The court will follow the recommendation of the state. Court hereby finding that there is enough evidence to convict Mr. Chafee of this offense, court will defer a finding of guilt, place Mr. Chafee on 8 years community supervision, order him to pay a $2,500 fine, $290 court cost, $770 reimbursement fees, restitution in the amount of $733.18. Court will order that Mr. Chafee be placed on the mental health caseload as a condition of his community supervision. Mr. Chafee, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward at this time to Deputy McLeish. You'll be fingerprinted. Ms. Caceres Perez, are you ready? Is your client in the courtroom? You may. All right, this is cause number CR 15393, State versus Kendall Martin Miller. So Mr. Miller, it's my understanding that you want to accept the offer being made by the state for you to return on May 24th, go into custody so that you can await entry into the safety program, rehabilitation program. Court will note for the record that I had you tested today for the presence of controlled substance. It indicated to me that you are negative today, so I'm gonna give you the request reset that you're asking for. So I'm order you to be back May 24th at 1:30. Yes, at 1:30. Actually, let's see. Yeah, go later. At 1:30. So he's gonna go in for safety. So we'll do 1:30 out at the Justice Center. Just let them know that you're there to accept a plea, enter into custody, and we'll conduct that out at the gym at 1:30. Okay. All right. So they have your reset form.
Yes.
Already signed it?
Yeah, I still need to report to my probation officer.
Yes, yes. I want you to check base with them and see what they want you to do to make sure that you remain compliant with all of your other conditions. And I want you, do you go by Kendall? You go by Mark?
Mark.
You go by Mark? Yes, sir. Okay. So Mark, I really want to stress this. I'm going to give you this reset because you've asked for it, right? Please don't use this as a time to go out and make your situation worse. I understand you got a drug problem. I understand that you're addressing it with the rehab. Don't allow this next 30 days to put you further behind than you already are.
Yes, sir. I'm using this to secure my home, so I have a place to go and get out of here.
I understand, but I'm saying whenever the pressure or anxiety, those things start beating down on you, don't use it. Don't take advantage of being out of the court's reach at this time and coming back to go and get high and to put yourself further behind. Yes, sir. Okay. Yes, sir. And if you don't show back up on the 24th, there's no guarantee that the state's going to continue their offer. There'd be no, even if they did, there'd be no guarantee that I would accept it. Yes, sir. Okay?
Yes, sir.
So while we're all putting a lot of hope and trust in you, we're gonna put the ball in your court. And whether you dribble it or not, it's gonna be up to you.
I'll be here.
All right? All right, so if you signed and you've got a yellow copy, you're free to go. So just check in with Mr. Waddell or your probation officer today. This will be good. Okay? You're welcome. Thank you for staying. I appreciate it. Mr. Pogue. All right, this is cause number CR 2276, State of Texas versus Mason Gregory Pogue. Mr. Pogue, if you will raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got,
Yes, sir.
all right, you may put your hand down. Mr. Pogue, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Adams. Are you pleased with his representation of you?
Absolutely.
Like you've had enough time to discuss your case with him, have all your legal questions answered?
Yes, sir.
Anything about this paperwork that you've read over and signed with Mr. Adams that you do not understand right now?
No, sir.
All right, and Mr. Adams, you believe Mr. Pogue to be competent?
He's confident, Your Honor.
Mr. Pogue, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram. A state jail felony carries a range of punishment of not less than 6 months or more than 2 years confinement in the state jail division of TDC. Also carries an optional fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
I see here that the plea agreement you want the court to approve is that you would plead guilty. The state's recommending that your sentence be assessed, your punishment be assessed today at 2 years confinement, the maximum in the state jail, with that being suspended and you being placed on community supervision or probation for 3 years, you paying a $2,000 fine plus court costs, restitution, and reimbursement fees. And as part of the agreement, the state would be dismissing a tampering, fabrication of physical evidence charge, and a harassment charge. Is that your understanding of the plea agreement?
Yes, sir.
All right, Mr. Pogue, understanding the range of punishment and the plea agreement, how do you plead to possession of controlled substance in penalty group 1, less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir. I'm guilty.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, court accepts Mr. Pogue's plea of guilt at this time. Mr. Adams, any objection to the state's evidence?
No objections, marked and offered.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
No, Your Honor.
All right, court will review the evidence. All right, court. Mr. Adams, did y'all fill that one out? There's another set of plea admonishments, another set of. all- Yeah, it was in the stipulation, it was in the middle of the stipulation for whatever. reason.
So they're under the bus. They're not.
All right, Mr. Pogue, the court's reviewed the evidence. I find sufficient evidence to convict you of this offense. Court will follow the plea agreement reached with the state. Court hereby convicts Mason Gregory Pogue of possession of a controlled substance of penalty group 1, less than 1 gram. Court assesses your punishment today at 2 years confinement in the State Jail Division of TDC. Court suspends that sentence, places Mr. Pogue on 3 years community supervision, orders him to pay a $2,000 fine, $180 restitution, $290 court costs, and to reimburse Van Zandt County $685. Court dismisses under section 1245, the tampering, fabricating physical evidence, DA 2021-858, and DA 2022-375 harassment. So, Mr. Pogue, tell me, if you go on probation and you violate, that means you don't report, you drink alcohol, you take drugs, or you violate any of the other conditions that are on here, what happens to you next?
I can go to jail for 2 years.
You can go to jail, you can go to prison, not jail, you go to prison for 2 years.
Yes, sir.
All right, so today I'm assessing the sentence. Your sentence is 2 years. Whether that 2 years happens to you is up to you.
Yes, sir.
You understand that, right? So if you go out and you violate, don't come in here asking for a better deal than 2 years.
Yes, sir.
All right? Hereby remain into the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward, Deputy Police, should be fingerprint right there. She's gonna take your fingerprint. Mr. Adams, did you have a pay sheet or are you gonna submit that later?
You follow.
You found it. If you want to turn it in, Patty's got some down there.
I figured out how to fill things in.
Yeah.
So that's why I told it.
Good, okay.
That's the legend.
Get your new bell and whistle.
That's all I have here on that.
Yeah, do you have anything this afternoon?
No, sir. I don't think so.
Have a good day.
All right, good. Have a good weekend.
You ready? Who are you ready on? Who are you ready on?
Mr. Coleman, Your Honor.
Brock Anthony Coleman, CR 17-6.
May I
Be
approach?
outside. Oh, there he is.
Mr. Coleman, please take the permission.
Thank you.
All right, go ahead, Mr. Ashmore.
May I approach, Judge?
You may.
Judge, the state and Mr. Coleman have reached an agreement. He is satisfied to the state's satisfaction. Its conditions, they have agreed. And of course, we don't oppose to discharge. We're asking the court to sign that order. His financials have been fully taken care of as of this morning. That's our announcement and our respectful request, Judge.
Is Mr. Coleman being terminated? He's already expired. So this will be. All right, the state having submitted the motion to withdraw the motion to adjudicate, court hereby grants that motion. Court hereby terminates the community supervision of Brock Anthony Coleman. Mr. Coleman, you're free to go. If you want to get copies of this, is this his
I do,
receipt?
yes, Judge, that's the receipt. And I have the others if you need to see them, but they're also showing the balances of financials to the county have been paid.
All right, I trust that's been done.
Thanks, Judge.
All right, I'm gonna give this to the probation department. If you want to get a copy of that,
Yes, please.
then see them outside, they'll bring it, okay?
Okay, thank you so much.
What they'll do.
Okay. All right, thank you.
Yes, sir. Thank you.
Michelle Stokes, 2020-9-4, and CR 2018. Right. All right. Are we doing a plea on?
We're doing a plea, may I approach? Judge, we have two offenses that arose from the same driving while intoxicated incident in Wills Point, Texas, back in 2020. The state has filed a motion to revoke and adjudicate. We've reached an agreement with the state for 3 sentences to run concurrent with 88 days credit for time served. We're asking the court to approve those.
All right, Ms. Stokes, if you'll raise your right hand. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
All right. All right, and let's see. And Mr. Ashmore, does your client waive the formal reading of the state's motion to adjudicate?
Yes, Judge.
And is it her intention to plead true to all counts alleged?
Yes, Judge.
All right, Ms. Stokes, you appeared before the court on cause number CR 2018 on February 27th of 2020. You pled guilty to the 3rd-degree felony offense of harassment of a public servant. The court heard the evidence, deferred a finding of guilt, placed you on community supervision for 3 years, and also ordered you to pay a $500 fine. On that same day, you also appeared in cause number 2020-9-4 on the charge of driving while intoxicated, a Class B misdemeanor. Court heard the evidence, found that there was enough evidence to convict you, followed the plea agreement on that day. Court deferred a finding of guilt, placed you on community supervision for 1 year, and also ordered you to pay a $3,000 fine. And your probation in that case was subsequently extended for a period of 1 year through February 26, 2022. It was during your term of community supervision that the state filed its motion to revoke your community supervision on November 17th, 2021, and also November 18th, 2021. Do you feel like you've had enough time to discuss both of these motions that the state's filed against you with your attorney, Mr. Ashmore?
Yes, sir.
You feel like you've had enough time to discuss it with him, have all of your legal questions answered?
Yes, sir.
Anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Are you pleased with Mr. Ashmore being your attorney?
Yes, sir.
All right, Mr. Ashmore, do you believe your client to be competent to enter into these pleas today?
Yes, Judge.
All right, Stokes, I'm going to ask you as to, in each case, as to counts 1 through 9, each individual count as alleged in each case. I'll take that back. In your DWI case, there's only 8 counts. As to counts 1 through 9 in the felony harassment of public servant charge, are those counts true or not true?
True, sir.
True. And in the DWI case, as to counts 1 through 8, are the allegations in those counts true or not true?
True, sir.
And are you telling me that each one of those counts in each one of these cases are true because the conduct alleged is true? You're not just saying that it's true so you can get a certain plea agreement, right?
Right.
Okay. And Ms. Stokes, has anyone threatened, forced, or pressured you to plead true to any of these today?
Yes, sir.
Okay. All right. Court will accept the defendant's pleas of true at this time. Mr. Ashmore, any objection to the state's evidence offered, which would be the defendant's plea of true?
No, Judge. We
Waiver of rights.
appreciate very much the several opportunities to extend this hearing. There were multiple negotiations with Ms. Heisel and the state prosecutor's office regarding her offers, including an offer to convict and stay on probation, an offer to go open to the judge, stay on deferred. And this is the resolution we've all agreed to after reviewing the original offenses knowing what the situation is, and we're asking the court to approve that today.
Is there anything further from the state? All right, Ms. Stokes, court, upon reviewing the state's motion, accepting your pleas of truth, court hereby finds that you have violated the terms and conditions of your community supervision in each case. Court will follow the plea agreement that you've reached with the state in cause number CR 2018 on the charge of harassment of a public servant. The court hereby adjudicates your guilt and assesses your, the court hereby adjudicates your guilt, revokes your community supervision, assesses your punishment at 3 years confinement in the Texas Department of Criminal Justice Institutional Division, and orders you to pay the balance of your financial obligations, including fines and court costs. And the court will award you 88 days credit towards that 3-year sentence for time that you've previously spent in jail on this cause. In cause number 2020-94 on the charge of driving while intoxicated, court hereby adjudicates your guilt, revokes your community supervision, assesses punishment at 88 days confinement in the Van Zandt County Jail, orders you to pay the balance of your financial obligations, including fine and court costs, and awards you 88 days credit towards your sentence for the time that you have spent in jail on that cause. Court hereby remands you to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Before I have you come up to be fingerprinted, Ms. Stokes, I want to know, you're emotional right now, right? Why are you emotional?
Because I was doing good at life, and whenever this happened, it really sucks that I have to go back from where I, ended up.
Yeah.
Like, I'm gonna miss my wife and my son and my family, and I was doing good, So,
Do you believe that you can get back to where you were?
yes, sir,
And why do you believe that?
because I'm strong, and I've got God.
So what's your life plan? Once you get through this, what's your plan?
Go back to work, take care of my family, be happy.
Keep judges like me out of your life?
Yes, sir. You have a beautiful face, but I don't want to see you again.
Understand. All right, Stokes. Court hereby remands you to the custody of the sheriff. I have you come forward to be fingerprinted with Deputy McLeish. After that, we'll take her into custody. Mr. Versace, are you ready? Yes, you may. Thank you, Mr. Osborne.
I know we need to visit photos of that, I'm just wanted to.
Yeah, that's fine. That's fine. And we don't have to do it this morning, but and we'll see you this afternoon.
Yes.
Awesome. Thank you. Or if we can have
approach.
Mr. Rodriguez. How are you today?
You're good yourself, John.
All right, Mr. Rodriguez, if you will, raise your right hand. This is cause number CR 18503, State of Texas versus Jose Rodriguez. Mr. Rodriguez, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. All right, let me put your hand down. Make sure you speak up loudly and clearly so I can hear you, so my court reporter can take down what you have to say, okay? Okay. Can you hear me?
Yes, sir.
Okay, thank you. All right, is your name Josue Rodriguez?
Yes, sir.
And Mr. Rodriguez, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Robert Versace. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss the case with him and have all of your legal questions answered?
Yes.
Is there anything about this paperwork that you've read over and signed today that you do not understand?
No.
Mr. Versace, do you believe Mr. Rodriguez to be competent today?
Yes, Your Honor.
Have you explained to him all of his legal rights as they pertain to this case?
I have, Your Honor. He understands all the obligations and consequences of this matter.
Mr. Rodriguez, I see here that you've been charged by indictment with a third-degree felony offense of indecency with a child by exposure. That carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and a fine, if imposed, of not more than $10,000. Do you understand that full range of punishment?
Yes, sir.
That means that if the court approves the plea agreement that's being proposed today, which is that you would plead guilty to that charge, and the state would recommend that the court review the evidence, not convict you today, but place you on deferred community supervision for 5 years, impose a $3,500 fine plus court costs and reimbursement fees. That if you subsequently violate any of the terms and conditions of your community supervision, and the state proves that to the court could convict you of this offense, adjudicate your guilt, convict you, revoke your community supervision, and assess your punishment anywhere from the minimum 2 years to the maximum 10 years. And you understand that, right?
Yes, sir.
So understanding the plea agreement, understanding the range of punishment that could be applied to you, you still wish to go forward?
Yes, sir.
All right, Mr. Rodriguez, at this time, I'm going to ask you, how do you plead to indecency with a child by exposure?
Guilty.
And Mr. Rodriguez, are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened, force, or pressured you to plead guilty today?
No.
All right, court will accept the defendant's plea of guilt. Mr. Versace, any objections?
No, Your Honor.
State's evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. The state is in client discussed the arson today. There is no I've seen it on file.
Thank you, Ms. Heimel. Anything further from the defense?
Nothing defense, rest of close.
All right, just take just a moment to review the evidence. All right, the court has reviewed the evidence. Court finds that there is sufficient evidence to convict Mr. Rodriguez of this offense. The court will follow the plea agreement reached between the state and the defendant. The court hereby defers a finding of guilt, places Mr. Rodriguez on 5 years community supervision, orders him to pay a $3,500 fine, $290 court cost, and orders him to serve 150 days in the county jail as a condition of his community supervision. Does Mr. Rodriguez have any credit towards the 150
He has
days?
150 days, Your Honor. It should stipulate in there from May 31st to October 27th of 2021, he was incarcerated.
Let's see here. Okay, thank you. I do see that now. All right, the court will award you 150 days credit towards that condition of your community supervision. Find that from the dates of May 31st, 2021 until the date of October 27th, 2021, you previously served 150 days. We'll show that condition of community supervision to be complied with at this time. Court also finds that this offense requires the defendant to register as a sex offender in accordance with Chapter 62 of the Texas Code of Criminal Procedure. All right, there also appears to be the matter of FM 21-511, matter of Marissa De Leon and Josue Rodriguez protective order. It's my understanding that there is an agreed protective order being requested today by both parties. Is that right?
Yes, Your Honor.
And Mr. Versace, do you represent the defendant on this matter as well? Okay, and so you have explained to him the requirements of the protection order?
Yes, Your Honor, we've gone over that on multiple occasions.
Ms. Heisel, do you know the cost of the protective order that would be attributable to the defendant?
$350 fees and
All right, and that's not, the court costs are not reflected in that. You want to go over that with your client?
If we could just.
Yes. So, yeah, I'll let y'all write that in. All right, Mr. Versace, any objection to the entry of the protective order and the assessment of costs, $350 cost of court and $250 reasonable and necessary attorney fees in this matter?
No objection.
All right, and cause number FM 21511, court finds that there are reasonable grounds to believe that the victim, cause number CR 18503, and the applicant FM 21511 is a victim of decency with a child as set forth in Chapter 7B, Articles 7B of the Code of Criminal Procedure. Court finds that Mr. Jose Rodriguez, the defendant, in CR 18503, and the respondent in FM 21511 has appeared and agreed to this order under Chapter 7B of the Texas Code of Criminal Procedure, and that he has also received the assistance of counsel in making this agreement. So the court hereby enters the protective order, granting protection as outlined in the order for a period of 2 years, and will continue in effect until April 28th, 2024. All right, Mr. Rodriguez, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department, so they can carry out the terms and conditions of the sentence and have you step forward to be fingerprinted with Deputy Police. After that time, we'll go over here to Officer Burns.
Thank you, Your Honor.
Thank you, Mr. Stacy. On this one. We'll just go ahead and put this on there. All right, this is clause number CR 14143, CR 14302. This is on the afternoon docket. Mr. Beth, having been released from custody, is present in court today. Court finds that the state and defense have requested the court on the basis of their agreement to reset Mr. Beth's motion to revoke hearing, which was scheduled today until June 28th, 2022. We will set that matter at 9 a.m.
All right.
Right, so as long as you're on bail, it'll be at 9 a.m. If you find yourself back in jail between now and then, it'll be at 1:30. Okay. You still need to report to probation. You're still under the order of that, so make sure that you don't, if you fail to report, then you're just gonna rack up more violations, and that's gonna make Mr. White's job harder to make you happy. Okay? Okay. All right, so you're free to go. We'll see you back on June 28th.
Thank you. Okay, Judge, and that does take care of it.
Thank you, Swag. So that would be 1 second. Should be good. On page 4, which was the wrong. Alright, so Mr. McCall his name loudly distinctly 3 times in the courthouse. I just think Mr. Watkins, he's here. Riser will be at 3 p.m. It's on sports docket. It's going to be at 3 p.m. That's what that is. Let's see, I think this pled. Mr. Rodriguez, were there 2 counts of indecency?
Or there were 2 different indicted cases, if we have dismissed the other.
Well, it's indicted though. 504. I've got a 503. The reason I don't remember seeing the 1245 judgment.
I'll get you a motion for dismiss on the other.
I could be wrong on that, but as I'm marking them off, don't remember having two charges.
I think there should have been a 25.
Mr. Watkins. All right, this is cause number CR 2201, State versus Michael Watkins. I show that we were set for status with probation today. State, do you have any knowledge on that? Or can you find the probation department? Can you find the probation department? I'm trying to remember what we had it on status for. Can you just remind was he said there's Sanctions court? I just want to explain to him what we're doing. All right, Mr. Watkins, the court had you set for status hearing, a sanctions court hearing regarding some of your conditions of your community supervision. one of the concerns they had was that you were not complying with your counseling and there was continued methamphetamine use.
I was, have trouble with my heart problems, and then I was confined to the home for, had a fungal infection, that got into my bloodstream, so I was contagious, so I was able to go to my counseling as like I'm supposed to. But I've been lifted from all that, and I can continue my counseling.
Here's the situation that you're going to find yourself in today, okay? Probation department has filed a motion to revoke your community supervision based on your admissions. This will be your 5th admission to methamphetamine while you've been on probation. I show that you were given a UA on April 25th. Is that's positive? Yes. So, Mr. Watkins, the court's already reviewed that motion, and I've granted that motion. So a warrant has been issued.
It's been issued. This is supposed to be a sanctions court.
I understand, but you've been moved to sanctions to a motion to revoke. So
Because I didn't know nothing about that.
I know, that's what I'm telling you right now. I'm telling you, I had you set to bring you in here to talk about these things, but the probation department believes that you're at the point now to where you should no longer be on sanctions court, and they have asked the state to file a motion. The state filed that motion to revoke you. The court's granted that. All right. So on the basis of that, there is a warrant for you at this time. So Deputy McLeish is going to take you into custody, and then I'm going to set you for a motion to revoke hearing. So if you need an attorney, you can request a court-appointed attorney, and we'll go through that process, and I'll set you for a hearing. Here today is April 28th. I'll set you for a hearing on May 26th.
Bond out on that because I have a lot of people's cars that I've got in my possession. Because I'm a mobile mechanic. I got to get that stuff back to them.
Let's see. I showed it's adjudicated, so it's straight. So unfortunately, you're not going to have a bond. Mr. Watkins, if you're going to need a court-appointed attorney, then when you get back to the jail, fill out that paperwork, go get it over, and I'll get an attorney signed for you. If not, if you're going to hire an attorney, then have a follow letter of representation. And I'm going to go ahead and set you for that that date in May 26th. All right. So if y'all get something worked out between now and then, I can get you set soon. Okay.